Hey folks, I'm attorney Roger P. Foley, and today I saw something that, I don't know, it made me want to pat a prosecutor on the back, and I'll tell you the story. I'm in court and there's a case going on, and the case involves animals, and you know that I don't take those cases. It's very rare that I do, and sometimes I do, but generally I don't take those cases. Because it bothers me when people harm dogs or don't do the right thing with animals generally. So it's hard to advocate for someone unless you truly believe in their innocence, but that's a whole nother topic. But anyway, this case involved animals, and a person was placed on probation and for the crime, and wasn't not a major case, but the person was placed on probation, and about a month into the probation, they basically did the same thing. Now, the defense attorney, he's a pretty well-known defense attorney. I don't know his name, but I've seen him around, and I'm sure I could go in the Google search and find him in 2 minutes, but it's irrelevant. But a guy who's been around for 30-something years, or I don't know, 20-something, 30-something, a long time, right? So he's kind of he's got a lot of experience behind him, and he was dealing with a prosecutor that is newer, one of the old buck, young buck, and I listened to the older defense attorney, the seasoned defense attorney, and he's negotiating with the state attorney. Now, I think those negotiations personally should happen over the phone or in email, and that's what I try to do, but everyone has their own style. Last minute in the courtroom while your client's in custody, that's a different style, but a lot of people do it that way. And I'm listening to I don't go and read the police report. I'm listening to what the arguments are. The person's already pled guilty. Person's already been on probation. They violated their probation doing the same thing, right? Usually when you have an animal case, you're not allowed to have animals, right? So anyway, I'm listening, and the defense attorney, in my humble opinion, I'm not trying to knock him, but he's coming across as a little bit arrogant. And I've made the mistake a couple times where let's just call him back. I've made the mistake a couple times because whether I've practiced for 10 years, 20 years, 30 years, or 50 years, honestly, it's quite irrelevant to the conversation, because you're not arguing your credentials versus their credentials. You're arguing the merits of the case. So this attorney throws that in, and he kind of comes across as a little smug and arrogant, like he's all-knowing, and the prosecutor is, new and unseasoned and doesn't know better, and nothing, I've never seen this ever, and that kind of thing. And as soon as he started doing that, in my mind, I go, you're going to turn him off. I've made that mistake before, and probably every defense attorney has made that mistake, right? But you learn from it quickly, and you don't keep making it. This guy's even my senior, right? So now I would think the prosecutor's like, hey man, that's what my offer is. It involves jail time, it involves reinstatement, but that kind of thing. And then the defense attorney, the supervisor, happens to be there, right? The lead of the division. And then he approaches. So now he's kind of discarded the person that he's negotiating with, like, hey, I'll just go to your boss kind of thing. And didn't really do it in a politically correct manner, or a manner that's like, hey, listen, I know you and I can't seem to agree, but are you okay with me speaking with your supervisor about it, the lead or whatever? He doesn't do it that way. It's not smooth. He just goes, and he starts to give the facts that really aren't quite accurate. He's slanting them, and look, we all do that as attorneys. We slant to our side, but in negotiation, you got to be open and you have to be truthful in what the allegations are, right? You got to at least acknowledge them. You may minimize them, but you can't just ignore them. And of course, the supervisor goes in and everyone's sort of watching because there's a lull in the action. The judge is taking a break. And then the supervisor starts going and looking at it and let me read it. And he's like, chatting up her ear. And I'm just thinking, like, there's no way. If I was a prosecutor, even as a defense attorney, I find his argument weak. Like, respectfully, I think his client should be charged with another crime. That's what I think, because they kept doing the same stuff. And the younger prosecutor said, hey, you know what? Like, obviously you're the boss, you do what you want, but I'm standing firm on my thing. And I saw the supervisor not just blindly back, but back, the newer prosecutor, and said, no, you got to deal with him on it. I don't see necessarily a reason to change it either. And it was, I don't know. There are certain things that you go to bat for. And I'm not saying you're selective, but you are selective. If my client has committed a first-degree felony, right, and they have a criminal history, I can't go, hey, could you just give me a withholding court cost, or could you just give me a 6 months of probation on something that you could have 30 years in prison for, right? It's just unrealistic. Granted, we weren't quite dealing with this situation, but again, I'm partial or biased because I'm an animal lover, and this case involved animals and kind of like a puppy mill sort of thing, and I'm not good with that. So I just sat back and watched, and I watched a seasoned defense attorney kind of get knocked down to reality a little bit, because the argument was incorrect. The argument had nothing to do with the facts or the merits of that attorney's client and what happened. The argument was really like, hey, in my so many years, I've never seen this. And that's the wrong argument. And I watched a young prosecutor, and if I could do a clap in the video, I'm not Mr. Editor. You see, I sit in my car. Kudos to the young prosecutor for standing his ground. Kudos to the lead and the supervisor that listened, but said, no, deal with the prosecutor. I don't see a reason for you to be with me on this. And they both basically stood their ground on what the offer was, which involved incarceration and a reinstatement of probation. I don't know. It for a weird reason, it made me feel good. I don't want to win a contest as an attorney because I'm bullying someone. I have a job to do, and I have to be open to both sides of the argument, right? If I'm playing, I don't want to call it a game, but sometimes you can make it analogous to a chess game. You have to understand what the move of the other person is, right? Their job is to prosecute. Their job is to punish. This person has already pled guilty to a charge and then violated a month later, doing basically the same exact thing that they were doing before. I just found the seasoned defense attorney's argument weak, and more of, hey, do you know who I am? As opposed to arguing the merits. And I watched two younger prosecutors stand their ground with a valid argument. And then here's the kicker. Then the judge reset it and said, you know, I see what you're doing, but I'm not sure that I'm going to accept this offer. You know, we're going to set it on such and such date, but hey guys, keep that in mind. And it even validated what I was thinking, and I think it validated those younger prosecutors, because here's the judge going, hey, I'm not saying I'm going to listen to arguments on both sides, right? Because the judge can't make a predetermined decision. But hey, I understand what's going on with this case to some extent. I'll listen to arguments on both sides, but I don't know that the offer that the state has conveyed is going to be accepted by this court. I don't know. Validation? What do you guys think? Anyway, I'm attorney Roger P. Foley. Have a great day. See ya.